When it comes to advanced technology that is necessary for everyday activities and contains personal information such as speech-generated devices, two issues are bound to come up: privacy and access. Speech-generated devices help people verbally communicate and also tend to contain personal information regarding the person using the device. This presents an opportunity for breaches in confidentiality between the user and the speech-language pathologists that aid the patient. The speech-generated technology obviously caters to the sense of hearing as it communicates a message out loud. However, this has presented problems with privacy because the technology does not allow volume control, directing, and timing of the messages. There is little way to direct messages with certain confidentiality when communicating it verbally through sound. Eavesdropping is common, and so the users have expressed concern with their privacy because of this. And in addition, users have expressed concern with their privacy and their SLPs, speech-language pathologists. The users have little control over whether or not the SLP might look at their log file or message buffer to learn what has been said or other private information without their permission. And in addition, the logs make what the user says and does even more permanent, as their history can be obtained, inspected, stored, and transmitted. So because of this privacy issue, a Health Insurance Portability and Accountability Act was implemented in 1996, which governs information that is stored and transmitted electronically. This rule inhibits SLPs to use a client's buffer or log except for treatment purposes, payment, or to conduct normal operations. They are responsible for protecting the confidentiality of the user, and if these rules are broken, there are legal penalties, monetary fines, and possible imprisonment for using this information intentionally or unintentionally. And in addition, passcodes have been created for these assistive technologies so that it protects the privacy of the user as well. More recently, speech-generated devices have been in a battle for funding and coverage via Medicare. Prior to 2001, the devices were considered convenience items and were not covered. However, between 2001 and 2014, Medicare agreed to cover these devices as they were considered durable medical equipment. They would pay for the devices that are necessary for those with disabilities. However, they would not fund any other function. So to get around this, people would start to sell these devices or computers without internet access because the internet access takes away the durable medical equipment label. But then once someone bought the device, the owner could pay out of their own pocket to unlock these basic functions, such as internet access. People worked the system so that they could have these devices funded, but also have the add-on so-called luxury features as well. In 2014, Medicare caught on and sent out a reminder stating that it would not cover any of the devices if they had the capacity to be unlocked. They ordered manufacturers to submit all their devices for recertification and reclassification. As expected, this caused outrage. But to make matters worse, in April, Medicare implemented a rule that these devices are only available for coverage through a capped rental period for 13 months and must be checked every month for eligibility for coverage. Once the 13 months ended, ownership is then transferred to the user. There were some caveats as well. Those who lived in nursing facilities or received hospice services for 60 days or longer were denied coverage and capped rental. In response to this, 27 senators and 173 representatives signed on to a bipartisan to Medicare detailing their concerns about capped rental and coverage in September. And thankfully, in November, Medicare rescinded their February clarification notice and communicated that they understood the need for texting and emailing to communicate in today's society and their importance for people with disabilities. According to the Ability Tools site, Medicare reverted to their pre-February 2014 treatment of SGD claims during this period and temporarily reversed the policy of refusing to cover these devices that may be unlocked. Though this sounds like a good thing, the capped rental rule remained the same. Users couldn't unlock their devices for the first 13 months and individuals in homes or hospice care beyond 59 days were still denied coverage. A year later, the Steve Gleason Act of 2015 was put into place. This accepts these devices from capped rental requirements bought on or after October 1st, 2015. And, effective on July 29th, 2015, devices were then allowed to be unlocked features that were previously denied. This is a huge win for the disabled community and users of assistive technologies today.